Hello, everybody.
Good evening.
We can start our second scientific seminar. Ladies and gentlemen, my name is Agnieszka Kryszczyńska, and I am a professor at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. I wish to warmly welcome you to the second scientific seminar entitled International Regulations Concerning AI. The main objective of the seminar is to establish and analyze the current international regulation of artificial intelligence. We have 6 members of the legal aspects of artificial intelligence team presenting their papers at today's seminar. For the first speech, I'd like to ask Professor Zbigniew Więckowski to present a paper titled International Regulations Concerning AI, Council of Europe Guidelines. Zbigniew Więckowski is a assistant professor at the Institute of Legal Studies at Cardinal Stefan Wyszyński University in Warsaw, a civil and private international law chair at the law faculty. Professor, the floor is yours.
Thank you. Dear professor, dear all, let me start. I hope this time my presentation will be more visible than last time. I will appreciate your confirmation.
Yes, we can see the presentation, looks perfect.
Thank you very much. Dear all, it's a great pleasure for me to present once again a presentation in front of you. And what I've prepared for today is the subject titled International Regulations Concerning AI, Council of Europe Guidelines. The aim of my speech for today is to give you some background about numerous activities undertaken by the Council of Europe in the field of legal aspects of AI. I strongly believe that we all could agree that the Council of Europe has the significant potential to be the role-playing international organization in terms of the ethical AI policy. I've divided my today's presentation into 3 sections. In the first one, I would like to speak about Ad hoc Committee on Artificial Intelligence and Permanent Committee on Artificial Intelligence activities. On the second part, I would like to pay your attention on the European Commission for the Efficiency of Justice work. And in the last part, I would like to speak about achievements of CDCG, which is European Committee on Legal Cooperation. I would be glad to answer any of your questions at the end of my talk, and I plan to be brief, about 15 minutes. Let me start with some figures and facts about the Council of Europe. The Council of Europe, as you know, is the oldest political organization, founded in 1949. For today, 46 member states constitute this organization, with a population over 650 million in total. The Council of Europe was set up to promote democracy and to protect human rights and the rule of law in Europe. From my perspective, the greatest achievement of the Council of Europe is the European Convention of Human Rights. As you know for sure, the Council of Europe has created a number of legal instruments known as treaties, like conventions, charters, or agreements. Please let me concentrate on those structures that are engaged in the AI policy. The first formalized structure constituted to analyze the legal framework for the development, design, and application of artificial intelligence based on the standards of the Council of Europe was the Ad hoc Committee on Artificial Intelligence. This Ad hoc Committee on Artificial Intelligence was established on the 11th September 2019, and the operational period for this structure was fixed for 2 years only, from 11th September 2019 until 31st December 2021. If you are interested in this structure, how it was created and what was the aim of this ad hoc committee, please feel free to see later on the official promotion movie. The link is visible on the slide below. The ad hoc committee on artificial intelligence resulted in 3 key documents. The first one was the feasibility study on a legal framework on AI design, development, and application based on Council of Europe standards. And this document was accepted in December 2020. The second document was titled Towards Regulation of AI System. And the third one, treated as a final report from the work of Ad hoc Committee on Artificial Intelligence, was the possible elements of a legal framework on artificial intelligence based on the Council of Europe standards on human rights, democracy, and the rule of law. And this document was accepted in December last year. As I said, Ad hoc Committee was established only for the fixed time, for the fixed period of time. The successor of this ad hoc committee is the permanent structure called Committee on Artificial Intelligence. The Committee on Artificial Intelligence is a permanent body and brings together representatives of the 46 member states, representatives of the observer states, representatives of other Council of Europe bodies and sectors, representatives of other international organizations like, for example, the European Union, representatives of the private sector, including companies, and representatives of the civil society and academic institutions. First meeting of this permanent body was held on April this year, and the next one is scheduled for the end of September. Hopefully, some papers will show up. The activities undertaken by those two committees, Ad hoc Committee and the Committee of Artificial Intelligence, have dealt mostly with general issues related to artificial intelligence. General issues like health, social issues, democracy, ethics. But in terms of activity relating strictly to the administration of justice, it is important to note two structures. The first one, the European Commission for the Efficiency of Justice, called out of French like CEPEJ, but in English CEPEJ, and the European Committee on Legal Cooperation, CDCG. The first committee was established on September 18, 2002, by the resolution of the Committee of Ministers of the Council of Europe. The purpose of this committee was to improve the efficiency and functioning of the administration of justice in the Council of Europe member states. The committee's task is primarily to collect and analyze data, develop benchmarks, draft reports, action plans, and to develop contacts with external stakeholders. One of the committee's important tasks is to conduct research on improving the efficiency of the judiciary through the use of the information technology solutions. On the one hand, as you know, the new digital possibilities appear as an opportunity to improve efficiency of justice. But on the other hand, they pose a challenge to respect the principles developed so far. It is important to note that the committee in December 2019 decided to establish a new working group titled Working Group on Cyber Justice and Artificial Intelligence. The committee entrusted the group with the task of developing solutions for the application of artificial intelligence mechanism and other digital solutions in the justice system in order to improve its efficiency and quality. The CEPESH CyberJust group has been tasked with developing training programs in the field of cyber justice and artificial intelligence. The output of this committee's works is really impressive. Please see on the slide how many documents this committee concluded for the short period of time. The first one is the European Ethical Charter on the use of artificial intelligence in judicial systems and their environment, accepted in December 2011. The second, the feasibility study on the establishment of a certification mechanism for artificial intelligence tools and services. The third, guidelines on video conferencing in judicial proceedings. The fourth, guidelines on electronic court filing and digitalization of courts. And the last one, revised roadmap for ensuring an appropriate follow-up of the CEPESH Ethical Charter on the use of artificial intelligence in judicial systems and their environment. European Ethical Charter on the use of artificial intelligence was the first European text setting out ethical principles relating to the use of artificial intelligence in judicial systems. The Charter provides a framework of principles that can guide policymakers, legislators, and justice professionals when they grapple with the rapid development of AI. And just to give you a short picture of the Charter, please look at the slide. Those 5 principles are respect for fundamental rights, principle of non-discrimination, principle of quality and security, principle of transparency, impartiality, and fairness, and the last one, principle under user control. The latest initiative of the committee is the Artificial Advisory Board on Artificial Intelligence, and it is interesting to note that among the members of this elite council is a Pole, Professor Marek Świerczyński, from our university, Kardynal Wyszyński University in Warsaw. The task of this group is to support the Committee of Efficiency of Justice on issues related to artificial intelligence in the administration of justice. The last structure that is interesting to note is the European Committee on Legal Cooperation. This structure was established in 1963, and it is a standard-setting body with a wide range of competencies in the field of public and private law. The CDCG's tasks include drafting conventions, protocols, guidelines, adopting opinions on legal matters, proposing standards on the protection of personal data and the right to private life. On the subject of issues involving artificial intelligence, this committee published 2 key documents. The first one guidelines on online dispute resolution mechanism in civil and administrative court proceedings, plus explanatory memorandum. And the second, guidelines on electronic evidence in civil and administrative proceedings, plus explanatory memorandum. I will be happy to present you next time those guidelines in detail, but for today, I would like to ask you for questions. If you have any, I will be privileged to answer them.
Thank you very much for your presentation. Are there any questions? I don't see any question in the chat. I wish to invite anyone to ask questions by using the chat section on the platform. If there are no questions for the next presentation entitled International Examples of AI Regulation and Practice, particularly for the criminal law, I'd like to ask Professor Istvan Ambrus, who is an associate professor of criminal law at the Eötvös Loránd University in Budapest. Professor, the floor is yours.
Thank you very much, Professor, and welcome everybody. I'd like to share with you my presentation. Please let me know if it appeared on your screen. Is it working now, or?
We can see the presentation. You can proceed.
Excuse me, does it appear yet or not?
Yes, we can see the presentation. Everything.
Oh, okay. Thank you very much. Okay, so today I'd like to share with you talk about some issues about artificial intelligence regulation and practice. Of course, with particularly talking about the criminal law, and I'd like to grasp some international examples where an artificial intelligence run agent, just like as we will see the so-called self-driving car already caused an accident, for example, and the question arises, how can we deal with the responsibility, especially for the criminal responsibility in these issues. As during the previous presentation by Professor Wiekowski, who shared with us the regulation of the EU, I only deal with the European matters briefly. However, I'd like to make an international outlook, especially for the regulation of some of the member states of the United States. Why could it be important to deal with the possible regulations in the US? As we will see in the field of the traffic law, we have an international convention back from 1968 declared in Vienna, which ties the hand of the legislator in most of the European countries when they're discussing how to regulate the matters of self-driving cars. However, of course, the United States is not a member of the before mentioned international conventions. Thus, it's much more easier for the member states, as you will see, just like the first of them, the state of Nevada and then Texas, to regulate the self-driving technologies, and of course, finally, the legislation of the artificial intelligence. Okay, I already mentioned one large issue, the self-driving cars, but before getting into the details, I'd like to mention some other issues according to the substantive criminal law. Of course, as every branches of law, the criminal law and of course the substantive criminal law should also conform with the constitutional issues. At least nowadays, it's still questionable in the, for example, in the European countries, how can we consider the artificial intelligence from the point of view of the constitutional law? Can we consider the artificial intelligence as a legal entity, for example, or not? But of course, it's not a task for the criminal law to decide. And we also have to mention that there's no comprehensive regulation yet according to the artificial intelligence. However, as on our last occasion I already mentioned, there's already a draft elaborated in Hungary by a committee of scholars and prosecutors, which could be previously a basis to regulate the artificial intelligence in the future in a comprehensive way. However, of course, when artificial intelligence is used for more dangerous matters, just like the before mentioned self-driving cars, there could be some regulation already found. And finally, which will be the topic or the main topic of my next presentation, the decision-making and the sanctioning system and using artificial intelligence during the sanctioning will be also a very important and interesting matter. As we will see, the question will arise which or what kind of sanctioning system will be more appropriate to use the artificial intelligence. I will only talk about this issue today very, very briefly. Instead, the main topic of my presentation today will be the possible regulation and practice of the artificial intelligence driven self-driving cars. Okay, let me start with an interesting site from Laszlo Vizsky, who was an excellent scholar in Hungary in the field of criminal law during the last century, and he stated that the foundation for the safety of traffic will be the personal performance of the driver for generations to come. And as we can see in the last few years, as the self-driving technology appeared and developed in a very fast way, probably in the next few years, not only the personal performance of a driver will be important in the traffic, but the self-driving technology itself instead. Okay, just a brief framework of the self-driving technology. It's a quite well-known categorization for the self-driving technology. As we can see, the zero category, where there's no automatization at all during the traffic. Or in the traffic, and the category 5, which will mean that the self-driving car will be just as smart during driving as a human being. And as we can see, nowadays we are actually between the second and the third step, when the automatization can perform the most driving tasks, but it's still needed for a human being to monitor the movement of the self-driving car. However, probably in the next few years, we will take another step and make the artificial intelligence driven self-driving cars more not just automatized, but also autonomous. Okay, of course, when we are talking about establishing the criminal liability, it's not enough, usually not enough just to breach any rule of the traffic law, for example, but in the field of the criminal law, we also will need a result, which could be a danger or usually an injury even. And of course, we should prove the relevance between the result and the breach of the law, and this will be the base to establish the criminal liability. Okay, an example from the Hungarian criminal law, we have two separated criminal offenses in the traffic law chapter or traffic offenses chapter, the dangerous driving and the causing a road accident. The before mentioned, the result of the before mentioned criminal offense, at least in the non-qualified cases, is to endanger another human being's life or physical integrity, and the second mentioned one when actually the perpetrator causes harm which will be recovered in more than 8 days, but the second mentioned criminal offense can be only committed by negligence. Okay, the sources of the traffic law, as I mentioned, the Convention on Road Traffic from Vienna 1968, and the Hungarian regulation is based on a joint decree back from 1978, which was, of course, amended for several times. And this one define the driver, and actually it states that a driver means any person who drives a motor vehicle or other vehicles and so on. And then the question will arise, can we say that this person who actually just sit in the car and only monitor the movement of the self-driving car, is he or she a driver or not? Of course, which was actually mentioned, the sources of the European Union. Of course, I won't show these again in detail. And finally, which I mentioned, we should observe how the member states of the United States regulate nowadays the self-driving cars, especially because, as I already mentioned, the United States is not a member of the Vienna Convention on Road Traffic, so it's much more easier to amend their law. And as you can see, Nevada was the first member state, and then Texas, and later Michigan and California also started to somehow regulate the self-driving cars. And which is interesting to mention that, for example, in Texas, it's only allowed to use the self-driving cars on the so-called test roads. But for example, in Nevada, it's actually possible to use it in the regular traffic. Okay, let's check the first case when a self-driving car caused an accident back from 2016. And the question arose if a dangerous driving criminal offense or the criminal responsibility for the dangerous driving was possible in this case. As you can see, what happened in this accident, finally the self-driving car got into this big vehicle, and it caused death in the traffic accident. And that was the first case when the question arises, how can we establish the criminal liability for these issues? In the Hungarian criminal law, it could be considered as causing a road accident. For example, if we consider that the negligence of the driver was possible to establish. However, we should first decide if he or she is a driver or not. And of course, if he or she isn't, then the last time mentioned and so so-called man behind the machine doctrine could be a tool to establish the criminal liability. For example, the criminal liability of the programmer of the self-driving car. Okay, what happened then in this? It's another case in the United States. This person who had a duty to monitor the movement of the self-driving car, he actually read a magazine during this drive, and the self-driving car finally hit a bicycle a rider person who finally died. And of course, several other issues should be, of course, considered and observed when we are trying to establish the criminal liability. Now let's check the possible solutions. We should probably incorporate another decree, at least from the Hungarian criminal law, which was only valid for the test driving. However, it defines the operator of the self-driving car. Probably we should amend the traffic law or amend the traffic law with this definition. Or the other solution, we could probably extend the definition of the driver, so it could be also possible to consider a person as a driver who only sit in the self-driving car and monitor the movement of the self-driving car. Another solution could be to extend the definition of the passenger who actually sit in the car in the recent regulation also, but he or she is not a driver, of course, so it could be another possibility. Or finally, we could somehow define a new category or in the traffic law or even in the criminal code, especially because at the end of the chapter for traffic offenses in the Hungarian criminal code, there are several authentical interpretations by the legislator. So we could somehow amend this section to make it possible to establish criminal liability if the self-driving car cause harm. Let's check the definition of the test driver from the aforementioned decree. It's a so-called Cahame decree, and it states that the test driver shall be able to take over the control of the vehicle. It's quite important because if someone read a magazine, for example, and not aware what's happening in the traffic, he will be or she will be liable if the self-driving car cause harm in the traffic. Okay, and finally, as I mentioned at the end of my presentation today, this will be the main topic of my next presentation, the sanctioning issues during the criminal proceedings. As we will see, as I mentioned, which sanctioning system would be more suitable for the using artificial intelligence during the criminal proceedings. Briefly, my opinion is that as more so-called cogent rules appear in a criminal code, which is actually the case, for example, in Hungary in the last 12 years, it will make the criminal code much more proper to use the artificial intelligence. Why is this the situation? If there's no possibility for the criminal judge to consider, for example, the aggravating and mitigating circumstances during the imposition of the sanction, but it will be mandatory for the judge to impose the concrete criminal sanction, then it will be possible to use the artificial intelligence instead of a human being judge, because if there's no possibility for a discretion, even the artificial intelligence can finally impose the so-called absolutely determinate sanction. Of course, only in that case, if the liability of the perpetrator was possible to prove. Okay, so these were the issues which I like to share with you today. So thank you very much for your attention, and please feel free to ask if you have any further questions. So thank you very much.
Thank you very much for your excellent presentation. Are there any questions for the speaker? I don't see questions in the chat. If there are no further questions, I wish to move on to the next presentation entitled Artificial Intelligence Regulations and Private Law, a Comparative Perspective, that will be presented by Professor Emond Veras, who is Professor of Private Law in Miskolc in Hungary and Cluj in Romania. Professor, you are welcome to present your research.
Thank you very much. And I want to check that if it's visible, the slide.
Yes, it's visible. We can see your presentation.
Okay. Thank you very much. And I would like to give a short presentation on AI regulations and private law from a comparative perspective. And I must say that this is not an easy topic, because we are in a very early stage of the development of regulating AI from the point of view of private law. So we cannot compare in many cases effective regulations, but we can compare contradicting opinions, legal literature formulated in different countries, and not judicial solutions or effective legal texts. And in this context, making a comparative analysis from a private law perspective is a real challenge. But of course, the topics are here and the debates are here. So we can say that AI is a hot topic in the field of information technology, and as a consequence, also in conversations, both private and professional, concerning what it may or may not do, and how it should or should not be regulated. So the topic is here, the debates are ongoing, and such conversations are oftentimes informed by the possible consequences of deploying AI tools for certain tasks. The legal literature abounds with the risks AI bias poses, AI failure poses. When it comes to algorithms, for example, predicting recidivism in a criminal law context, or setting time limits for detention, and or possible discrimination or bias during hiring and layoffs of employees, risks to highly personal data security, and the risks even to human lives. So from this perspective, the private law and the criminal law perspectives have something in common. Of course, there is a difference, but not predictable and illegal behavior consequences of AI must be tackled also by the criminal, but also by the private law. Private law, of course, will concentrate on the damages caused. And somehow, the large part of legal literature seems to be very informed in its inquiries, somehow in way that is inspired from nightmare scenarios presented from works of dystopian sci-fi, and of course they are ringing the bells of a moral panic. But if we look back on centuries of history, we can say that this type of psychological reaction accompanied all type of technological innovations. We can start from the Jacquard loom or the steam engine, or railways or subways, or air travel and information technology even. And of course, this is somehow explainable because in all these cases, the new technology seemed to be a competitor of the human being. And this is somehow repeating itself in the case of AI, and this psychological reaction leads to in many cases to this nightmare scenarios, dystopian scenarios, panic-driven approaches, like we will lose all the jobs and so on. And of course, this is not a precise image on the AI and the effects of AI. And it should be noticed that this dystopian literature almost never makes any references to rules of civil law. If we look back also in the history, the Orwellian nightmare or Huxley's Brave New World are both governed by intricate rules of conduct, formal and informal, which with few exceptions manifest themselves in the fields what we can call from a university approach as disciplines like administrative law, constitutional law, criminal law, and not civil law, not private law. So civil law practically concerns AI and regarding possible AI applications, and in what we follows, I will concentrate my efforts on exploring these concerns in a comparative legal literature in the following distinct fields: non-contractual liability for damage caused by or with the participation of artificial intelligence, and the second one is artificial intelligence as a party or participant in a contractual relationship. And we must note here that most problems evoked are treated by the authors both from the legge lata and both from the legge ferenda point of view, but the basis for comparison used when treating them is more rather the legge lata approach, because we cannot predict at this moment the exact content of future AI regulation. And let's see the non-contractual liability of AI or for AI, and actions taken or facilitated by AI have become the focal point of legal research, especially when these are apt to result in bodily harm or other damage to human beings. And of the categories of AI-operated machines, of course, none have attracted more attention in this field in the comparative law research than self-driving vehicles. However, it should be noted that AI may cause damage, and therefore liability issues may also arise when no machinery was operated, just the result was produced and resulted in damages. For example, automated risk assessment for a loan applicant, for example, and this poses the risk of causing harm as well, and no machinery is in question. The current legal literature in private law, however, focuses on self-driving vehicles, and the damage AI may cause while operating them is practically unresolved, as different legal systems use different solutions to impose reparation of damage caused with or by a specific machinery. Most systems employ either some presumed fault-based liability for this purpose. The driver or the operator of the car, for example, is presumed to be at fault for the accident, or liability is not based on any fault, objective liability, in which case the fault of the machinery is supported by the owner of or by the operator. The practical outcomes are similar, because the owner or the operator will be liable, but the ideological background is totally different. And practically we can say that a version of the second, the objective approach, practically is using the system of product liability for the case of AI. And these solutions raise the classical issues well known in the field of responsibility for objects or for their damage causing effects. And practically what we can say, and to conclude on this issue, that reviewing the quasi-totality of rules which can be applied to robotics, the legge lata, we have a 2017 European Parliament recommendation on civil law rules on robotics, and this is a main reference point at this moment, which was based on extensive research activity. Practically, this set of recommendations says that no restriction of liability caused by a non-human agent, so the restrictions are not possible, and risk management approaches are necessary. In general, an insurance which must also supplement the use of the strict liability rule. So an obligatory mandatory insurance scheme must be designed in the near future to cover the risks, because in many cases the classical approaches are can be applied, but the results are not perfect. For example, we can have many entities which contributed to the self-driving car, for example. And there is an inherent opacity of AI operation. And this kind of setting the liability rules is complicated, because we can say that the driver of the owner is the beneficiary of the activity of that machinery, and so they can respond from a civil law point of view. But what we can say about the designers and constructors and informaticians liability, we can exclude that of the chain of responsibilities. We cannot do that. So the better option is to create a mandatory insurance scheme, which practically is putting away all these civil law disputes, but for the person who suffered the harm leads to a certain solution. Of course, in the time we must deal with the main problems which are posed by the AI in this context. The second issue, and I will be very short, is the question of AI as a party in or as participant in a contractual relationship. And we can say that in this case, in the field of contractual liability, it's also a liability question at the end. The analysis of AI regulation from a comparative perspective must take into account the particular situations in which AI is a tool of contractual performance, or AI, and we have such cases at a relatively large scale even now, it is empowered to participate in the conclusion of a contract. So in the first situation, the general rule of contractual liability, that attributable non-performance leads to liability, is applied in the comparative law, but this must be in many cases completed by the objective strict liability for objects, for things. Otherwise, the system is not fully functional at this level. And this is ongoing issue, and the attributable character of non-performance, which is presumed in many legal systems, may be challenged on several points, and these challenges are valid in most of the EU legal systems. Firstly, one might state that the AI infrastructure used was state of the art, and therefore it was certified to being fit for a certain purpose. And if it displays behavior which the operator is unfamiliar with, or this is a specific risk, and how we can deal with that. So, or second defense is the operation of the system due to the innate opacity is not under the influence of the operator, so the operator cannot be liable for faults which are inherent to the AI. The operator may be even unaware, not knowing the way in which the AI system actually achieved a certain result. So this is the system is working in such way. Asset liability, product liability cases are complicated even more than in case of normal issues in the context of AI. So to conclude, private law research in comparative law at this moment is concentrating and must concentrate on issues of liability, because these are the first ones which are reaching actually the courts even now, having in mind, for example, the cases presented also at this event related to self-driving cars. But of course, we must design somehow, using old methods, old regulations, old concepts, something which is apt to give responses then raise more and more questions. And this is not an impossible task, but we have to be very flexible, and we must create a framework which can adapt on the move to the development of the applications of the AI. So there are a lot of questions, very few regulation, maybe except in some countries we have rules for self-driving cars, like Germany. But this stage of development of private law is at this moment is very far from giving definite answers to the questions raised by the AI. Thank you very much.
Thank you very much for your presentation. Are there any questions for the speaker? If there are no questions, I wish to proceed to the next presentation, entitled Challenges to the Codification of Administrative Procedure in the Regulation of Artificial Intelligence. The presentation will be presented by Professor Barnabas Hayas, who is an associate professor at the Constitutional Law Department of Pazmany Peter Catholic University, Faculty of Law and Political Science, and a judge at the Supreme Court of the Hungary. Professor, the floor is yours.
I try to share my screen. It's okay. My presentation is on this seminar is examples of the application of AI-based technologies in public administration. The difficulties on codification was the former seminar, my topic. So the administrative, substantive law and procedural law have a really strong...
We do not see the presentation. Did you share your screen with us?
Yes.
Oh, now we are. You can see something. Yes.
Okay.
And the slideshow maybe would be can give us the better visibility of the presentation.
Okay, this form or this. You see my presentation, or yes,
we can see your presentation, but it would be better if you could turn on slideshow.
Yes, I
can
tried
see
it.
The slides on this left side.
Yes.
Diavetítés gombot ott fönt.
Igen, azt megnyomtam, és én magamnál azt látom, hogy megy a slide.
Képernyőn nem az van sajnos, igen.
Igen.
F5, az is kellene segítsen.
Nyomtam azt is. Akkor megosztom újra. Most talán?
Excellent. Now we can see the slideshow.
Okay. So, the administrative, substantive law and procedural law have a really strong national character. So, national regulation is typical in this era, and the public administration often use AI tools without explicit regulation. So I think I have to talk about some perception of public administration. Few weeks ago, I went to a car service where it was advertised that our service can be good, cheap, and fast, and you can choose from these three too. As if it were a public administration, isn't it? Our topic is artificial intelligence, not public administration in general. So I am only listing some of the most commonly known perceptions of public administration. Perhaps there is no country where public administration is considered fast, cheap, and good at the same time. I think you could continue this short list until Christmas. And if we see the goals and effect, the AI application for the public administration, as if many AI tools were a response, directly a response to our perceptions of public administration. We don't have enough time to explain the administrative application possibilities of all AI tools. So I focus on typical solution. Each AI tools may connected to other applications, so they must be examined with attention to each other in most cases. The first tools are virtual agents, virtual assistants, or chatbots. These tools are computer-based systems, interact with the users by means of speech analytic, include real-time universal translation and/or so-called NPL, natural language processing system, and the softwares can perform tasks for humans. I listed some examples. They are more or less well known. For example, Emma chatbot developed for the immigration services for Homeland Security. This assistant is intended to help the people on request pertaining to immigration services, green cards, passports, and any service offered by this department. This bot is bilingual, Spanish or English, and the English-speaking bot is enabled to ask us as voice through speech. And you can get any information about this department or let you walk through the website. And Emma handles monthly at least 1 million interactions. One of my favorite example is the Alex, or not the Alex, so Miss Alex or she. She was an Austrian taxation office chatbot with a really good navigation and citizen experience, and it was so effective that she has many successors in Australian government, and other Alex, 2 Sams, and some nameless bots. The implementation of Alex resulted in almost 80% of client inquiries answered without the need to follow up with further interaction with the taxation office. With Alex, the taxpayers earned about 10 million Australian dollars per annum. And Alex has contributed to the 8-10% reduction in contact center call volumes. You can check, for example, Wienbot in Austria, Vienna. You can ask about dog registration, about parking fees, and so on. I tested yesterday. It's really funny. And you can find many chatbots. These virtual assistants basically provide information and does make administration easier for the citizen, make an higher level citizen experience or customer experience in public administration. An assistant can also help fill out the forms. There is also a virtual assistant who, if she or he does not know the answer, ask for human help to answer for the citizens, for example. It is important these tools do not make decision, nor do they directly support to the authorities' decisions making. The predictive analytic is also really common in public administration. It's based on data-driven technologies and used big data methods with machine learning or deep learning. Some predictive analytic systems are already part of our everyday life or have become part of our lives in recent years. For example, the modern meteorological, hydrological, agricultural forecasting modeling systems, or for example, COVID contact tracing tools are some. And we often don't even notice it. For example, predictive policing, forecasting crime risks, fraud detection systems. In everyday life, we don't take any contact with these systems. Identity analytics is also very often in the public administration. It is also combined with big data, may include deep learning and machine learning as the the former tools. In Hungary operates the so-called central identification agent. This agent is not agent as the virtual assistant. The e-administration services can be assessed using via this tool, this so-called central identification agent, even after face recognition or voice recognition, but government use of identification systems can be based on biometric data. These systems are more typical in in work of law enforcement agencies. On the slide, you can see some examples. From these three, two are from the US. Easy passport control can you use also in everyday life. This is the biometric identification system of European passports. So if you take a plane, take a flight, you can use this tool. And for me, this is the most important. The process automation systems, the AI-based process automation systems can be innumerable diverse, from the fully automated decision-making systems through decision-making support systems to applications preparing for draft of citizen declarations. They can also be based on many different technologies. I think these are the most interesting tools from the point of view of administrative procedural law. And shortly about Norwegian example or way of Norway. The Norwegian example is really important because in addition to the general procedural rules, as I mentioned in Hungary last times, and by amending the sectoral rules, the door was opened wide for fully automated decision-making process or decisions. In all cases, the possibility of human review is assured in Norway in these cases. And it is also important that not all cases have a way to make an automated decision. For example, fully automated decisions permitted where the decision is slightly invasive or non-discretionary unless indubitable proper case processing, and it must be compatible with the data protection right. The technologies are really different. Can use RPAs. Last time I mentioned robotic process automation, or may include rule-based assessment, workflow processing, schema-based suggestions, or any big data tools can also used in this. And I have to make some conclusion. As a final remark, I know that that a multitude of legal, also fundamental law, regulatory and ethical questions arise in connection with the use of all of the mentioned tools, which I will discuss in later stages of research. It's really important that in many many countries in diverse AI tools which is used in public administration has not a well-regulated basis or background. It's clear that in Europe the GDPR rules must be fulfilled with these tools, but I think the lack of regulation in this area is clear, and it's also really important from data economic perspective, that the countries, the states are sitting on a huge mountain of the data. They are personal data and any kind of data of the working of state, about the population and so on. This big amount of data, I would say they are calling the AI-based solutions for the public administration or the governments. Thank you for your attention, and I hope I was in my time. Thank you.
Thank you very much for your presentation. I don't see any questions in the chat, so we can move forward. The next presentation will be presented by myself, and it will be on the current state of work on the regulation laying down harmonized rules on artificial intelligence in the European Union and its impact on law enforcement and the administration of justice in Poland. So I will try to share my screen. I think. Okay, I don't know if it's visible. I'd like to ask if my presentation is visible.
Yes, now it is visible.
Okay, thank you very much for confirmation. Okay, so the proposal of a regulation on artificial intelligence was announced by the Commission in April 2021, and it aims to address risks of specific uses of artificial intelligence, categorizing them into 4 different levels: unacceptable risk, high risk, limited risk, and minimal risk. And in doing so, the artificial intelligence regulation will make sure that Europeans can trust the artificial intelligence they are using. The regulation, I don't see if those slides are changing. And the regulation goes hand in hand with the coordinated plan on artificial intelligence, and due to the links between the documents, before I focus on the draft regulation, first a few words on the coordinated plan. Okay, something is wrong with changing my slides. Okay. The 2021 Coordinated Plan on Artificial Intelligence, published in April 2001, 2021, sorry, builds on the collaboration established between the Commission and the Member State during the 2018 coordinated plan, and it sets out the strategy to accelerate investments in AI technologies to drive resilient economic and social recovery, aided by the uptake of the digital solutions, act on AI strategies and programs by fully and timely implementing them, and aligned AI policy to remove fragmentation and address global challenges. It will do so by setting enabling conditions for artificial intelligence development and uptake in the EU, making the EU place where excellence delivers from the lab to market, ensuring that AI works for people and is a force for good in society, and building strategic leadership in high impact sectors. The 2021 review of the coordinated plan provides an overview of actions taken since the adoptions of the 2018 coordinated plan, and sets out an outlook with the concrete proposals and recommendations for further actions. Identifying areas where the partnership between the EU and the member states is particularly effective in making Europe a hub for development and use of cutting-edge human-centric AI. So we have some objectives and interrelated joint actions areas for collaboration between the European Commission and the member states, for set enabling conditions. We have also proposals for excellence, proposals to ensure that AI works for people, and the most interesting for us, key proposals to build strategic leadership. In addition to the horizontal actions, the 2021 review of the coordinated plans put forward 7 sectoral action areas. Artificial intelligence systems, if designed and used in accordance with democratic principles and fundamental rights, can become central technology to support, but not replace, home affairs authorities and strengthen security. In particular, law enforcement authorities should be able to act in a rapidly changing and evolving criminal landscape to enhance the protection and safety of all persons. And I can also improve cybersecurity, for example, by assisting in threat intelligence through the recognition of patterns based on past experience, by reducing incident response times and facilitating compliance with security best practice. So by joining forces and in full compliance with fundamental rights, member states, law enforcement and other authorities can address more effectively the new challenges posed by the immense quantity of data, ever more sophisticated and complex criminal activity, and use of AI by criminal organizations, in particular in cybercrime, as well as the increasing requirements for smooth, quick, and user-friendly procedures. AI technologies are used for data analytics, for example, augmented and virtual reality to model public safety in mass events, the automated detections of cyber threats, search and rescue operations with drones and robotics. And so we can see the possibility of use. In order to enhance transparency, explicability, and public trust, the Commission will launch a call for dedicated common European security data space for law enforcement, will assess the feasibility of data management and data science framework at EU level for law enforcement, will found a project to develop a global toolkit for law enforcement agencies, will continue launching proofs of concepts for concrete use case of artificial intelligence in the field of regular border control, migration, and police checks, or continue funding research and innovation on AI for application and knowledge base for law enforcement. And of course, the Commission member states and the relevant European Union agency will, for example, work together in the context of the European Union Innovation Hub for the internal security. So as we can see, those objectives are quite important for also, let's say, the use cases of in artificial intelligence. Now I would like to go to the draft. I wish to proceed to draft Artificial Intelligence Act. And what is important, the draft will have GDPR-style extraterritorial reach and applies to providers that market in the European Union or put AI system into service in European Union, users of AI systems in the EU, and providers and users of AI systems whose output is used within the EU. The draft regulation defines the term provider as a person that develops an AI system or that has an AI system developed with the view to placing it on the market or putting into service under its own name or trademark. It should be noted that any distributor, importer, user of or other third party will be considered as a provider if it puts an AI system on the market under its own name or trademark, modifies the intended purpose of an existing AI system, or makes substantial modifications to the AI system. And the term user is defined as a person using an AI system under its authority, except where the AI system is used in the course of personal, non-professional activity. Notably, the draft AI regulation provides for a horizontal regulatory framework. Existing regulations, law, standards, norm, etc. Of technology in the most cases apply to specific industries and do not address the implementation of this technology through the hardware and software systems. And the proposed regulation will attempt to regulate AI horizontally and thus independently of use case. And the proposed regulations does not set out a definition of AI. Instead, it provides a definition of AI systems. So artificial intelligence system means software that is developed with one or more of the techniques and approaches listed in Annex 1 and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. So the list of techniques and approaches in Annex 1 includes machine learning approaches, logic and knowledge-based approaches, as well as statistical approaches. The overly broad definition of AI systems in the draft regulation has gained criticism from various stakeholders, while it remains to be seen that the final version of the draft AI regulation would look like. Some states proposed a narrower definition of artificial intelligence with 2 additional requirements: that the system is applicable of learning, reasoning, or modeling implemented with the techniques and approaches, and that is also a generative system directly influencing its environment. Recognizing that artificial intelligence systems can deliver a wide array of economic and social benefits, regulation seeks to strike a balance between fostering investments and innovation in AI systems and addressing the risks associated with AI systems. And to achieve this balance, the regulation adopts a risk-based approach. The draft regulation divides AI system into, it depends, 3 or 4 categories. So I can see 4 categories in this regulation. So it's unacceptable risk AI systems, high risk AI systems with transparency obligations, and minimal risks AI systems. And what is important, some artificial intelligence practice shall be prohibited. And I will, of course, skip to those interesting for the law enforcement perspective. But I'd like to focus that Title 2 of the proposed regulation prohibits AI systems that pose an unacceptable risk to society. So these include AI systems intended to manipulate persons, subliminality, exploit vulnerabilities of particles, particularly vulnerable groups, and perform social scoring by government for general purposes. So we will skip to the next slide. And what is forbidden? The use of real-time remote biometric identification systems in public accessible spaces for the purpose of law enforcement, unless and in as far as such use is strictly necessary for one of the following objectives. For example, the targeted search for specific potential victims of crimes, including missing children, or, for example, for the prevention of a specific substantial and imminent threat to the life or physical safety of natural persons or of a terroristic attack. And if you are talking about unacceptable risk AI system, the use of real-time remote biometric identification system in public accessible spaces for the purpose of law enforcement for any of the objective referred to the paragraph 1.d shall take into account some indicated elements. For example, the nature of the situation giving rise to possible use, in particular, the seriously probably scale of the harm caused by in the absence of the use of the system, the consequence of the use of system for rights and freedoms of a person concerned, in particular the scenarios, probability and scale of those consequences. We have also indicated high risks AI systems, and the following categories of AI systems fall under this category. Here we have law enforcement, administration of justice, and democratic processes. As my time is almost finished, I will go to show only the Annex 3. High-risk AI systems referred to Article 6 and artificial intelligence. Here we have administration of justice and democratic processes, AI systems intended to assist a judicial authority in researching and interpreting facts and the law, and in applying the law to a concrete set of facts. We have also some obligations. So Chapter 2 of Title 3 imposes data and data governance standards requiring providers of high-risk AI systems to train their models with training, violation, testing, data sets, and so on. And Chapter 2 also imposes requirements on providers of high-risk AI systems relating to documentation and record keeping, transparency and understandability, human oversight, accuracy, and cybersecurity. And we have some substantive obligations also included. We can also see that some AI systems can be matched with the transparency obligations. So the Title 4 creates transparency requirements which draw inspiration from GDPR for certain AI systems. This includes AI systems that interact with humans. For example, chatbots are used to detect emotions or determine association with social categories based on biometric data, or generate or manipulate content. For example, deepfakes. Providers and users of these AI systems must inform individuals of the operation of such systems so that they can make an informed decision of whether to interact with them. And the last category are the minimal risk AI systems. There are some AI systems. For example, a simple spam filter would fall within this category. There are no compliance requirements for such systems, and vast majority of AI systems currently used in the European Union can be defined as minimal risk AI systems. I will skip it because we don't have time for this. The use of artificial intelligence in law enforcement entails a number of potentially high and some cases unacceptable risks for the protection of fundamental rights of individuals. in the process of decision making, different types of discrimination, errors inherent in the underlying algorithm, which can be reinforced by feedback loops, as well as risks of the protection of privacy and personal data, the protection of freedom of expression and information, the reassumption of innocence, the right to an effective remedy and fair trial. Of course, AI solutions for law enforcement and the judiciary also need to fully respect the principles of human dignity, non-discrimination, freedom of movement, the presumption of innocence, the right of defense, including the right to silence, freedom of expression and information, freedom of assembly and association. Any AI tools, either developed or used by law enforcement or the judiciary, should, as a minimum, be safe, secure, fit for purpose, respect the principles of fairness, data minimalization, accountability, transparency, and so on. So as we can see, we have a lot of challenges. Of course, the regulation, before it comes law, must pass through the potentially lengthy process. If adopted, it will be one of the first major AI regulation to arrive on a global stage. Legislators and regulators around the world are now being to move beyond high-level principles and policy frameworks for frameworks to hard law with the serve penalties for non-compliance. So given the lack of AI regulation in Poland, we expect European Union artificial intelligence regulation to fill this gap. I thank you for my presentation, and I'd like to announce the next presentation. The next presentation, Professor Rafał Wielki is with us, and Professor Rafał Wielki will present a presentation entitled Good Practices related to the implementation of artificial intelligence legal regulation. Professor, the floor is yours.
Thank you very much, Professor. Dear colleagues, dear guests, today I would like to focus on an overview of proposed regulations in various places around the world. While regulations are still lacking in many parts of the world, there is a lot of discussion about them, and artificial intelligence, like any innovation, brings both opportunities and risks. So therefore, it is important to consider these issues before designing the law. So when we're talking about opportunities, we can talk about reduction in human error, because computers, however, do not make these mistakes if they are programmed properly. With AI, the decisions are taken from the previously gathered information, applying a certain set of algorithms, so errors are reduced, and the chance of reaching accuracy with greater degree of precision is a possibility. Also, we can talk about taking risks instead of humans, because this is one of the biggest advantages of AI. We can overcome many risks, risky limitations of humans by developing AI robot, which can turn the risky things for us. It could be going to Mars or defusing bomb, exploring some difficult places, and this could be used effectively. Also, we can talk about helping in repetitive jobs. day-to-day work, sometimes we are performing many repetitive works like sending, thanking email, verifying some certain documents for errors, and many more things. And using AI can productively automate these tasks and can even remove some boring tasks from humans. Uh, Also, we can talk about faster decisions because using AI alongside other technologies, we can make machines do decisions faster than human and carry out actions quicker. That's because humans, while taking a decision, will analyze many factors, both emotionally and practically, and AI machines don't do this. But on the other side, we can also talk about risks. Uh, this is high cost of artificial intelligence. Software programs need frequent upgradation. We need to cater the needs of the changing environment. Also, if there's some kind of breakdown, the cost of fixation is very high. Also, we can talk about no human replication. So, no matter how smart a machine becomes, it can never replicate a human. Machines can be rational, but they are very inhuman. They don't possess emotions and moral values. They don't know what is ethical, what's legal, and that's could be a large problem. Also, they cannot replicate the human connection that makes the team. So they cannot develop a bond with humans, and which is often an essential attribute when it comes to team management. The problem is also in the risk in lack of creativity because machines can't be as creative as humans. And also, we can talk about the risk of unemployment. Artificial intelligence is replacing the majority of repetitive tasks and other works with robots. Human interference is becoming less, which is because of employment standards. So I think that it is good to take under consideration some socio-ethical issues that seemed crucial in regulations. Now I would like to focus on some proposed solutions and good practices in different countries or regions that are based on artificial intelligence economy. They have a lot of high-tech startups that are crucial for local economy. So I would like to present what propositions are present in European Union, United Kingdom, United States, and Israel. So in the European Union, we can say that this is a human-oriented approach because there is a following goal: to become a global leader providing cutting-edge, ethical, and secure human-centric AI solutions. Humans are supposed to be at the center of the solution. And the European plan is a number of measures to support the development and application of AI in Europe. This includes maximizing investment in public-private partnership, increased funding for AI startups and small, medium-sized enterprises. Also, it's creating and connecting digital innovation centers that can help apply artificial intelligence to small and medium-sized enterprises, adaptation of training programs and systems, creating European data spaces regulated through GDPR, and ensuring that AI solutions are ethical and reliable. But we also have to focus on credibility of AI. What does it mean? In the European Union, it is noticed that AI may possess many risks. So there is the key here is the creation of ethical and legal framework within which European Union position as a leader in implementation of innovative AI solutions. We talk about credibility, that it should comply with current regulations, it should adhere to basic ethical principles and values, and should be reliable, technically reliable, while taking into account the social environment, so it cannot cause any even unintended harm. To be more precise, what do we think about? We're talking about human leadership and oversight, assisting the development of democratic and just society by strengthening human leadership and supporting fundamental rights. Also, stability and security, creating safe and technically reliable solutions. Privacy and data protection, ensuring that citizens have access to adequate control of their own data. Transparency, ensuring the traceability of AI systems. Diversity, non-discrimination, ensuring diversity and equal fair treatment. And social environmental well-being, enhancing positive social change, and also accountability, ensuring accountability mechanisms for AI systems are and their performance. It's a little different in United Kingdom. Here we have an approach that is science and business oriented, and it's focused on 5 pillars. One of this is ideas. It means that the main goal of the strategy is to make UK the world's most innovative economy. This is to be made possibly by investment and increased spending in research and development. Second pillar is people, because collaboration with universities is expected and to be the backbone that will provide highly qualified AI researchers and workers. Third pillar is infrastructure. And here we talk about supporting primarily in the area of data. The idea is not only to improve the current data infrastructure, but also to increase the quantity and availability of high quality public data. Fourth pillar is business environment. So in the UK, they are ambitious to become the best economic ecosystem for starting and growing AI-based businesses. And the last one, we're talking about places. So this is a local approach to AI policy. The creation of national strategy is intended to mobilize regions to create their own AI strategies, and of particular importance in the issue of transportation between regions and cities that could be incubators of for the business in the future. Let's have a look at American approach, because we can call it a don't disturb approach. We don't have, in the United States, that is one of the world leaders in AI. There are inspiration from many startups, form of massive ecosystem, but the national strategy in the field of AI doesn't exist actually. It means that the federal government is primarily focused on not blocking the development of AI-related businesses and not creating additional costs with unnecessary regulations. So at the time, it has safety and market fairness in mind, but the idea therefore is to prepare regulations that will create a minimum framework for ensuring safe AI-based solutions, but not restrict their innovations. Although the US is also concerned about ethics, but it has placed priorities in its strategy that are considered ethically controversial, like the government has set the goal of development of AI weapons system, and there is an international discussion about the potential of AI intelligence-controlled weapons, because autonomous systems allow for greater precision and safer for human execution of military operations, but on the other hand, the absence of human factor in the control of armies raises legal and ethical concerns. And also there is another way, because Israel is called a startup nations. This approach can be named as safety-oriented. In strategies and propositions, good practices presented in Israeli documents, we know that Israel should create a national solution for infrastructure issues like hardware, cloud, internet connection. So they want to be independent from external systems and should allocate an ongoing budget, because the security community, unlike the civilian industry, has needs that don't usually allow for using commercial infrastructures. Also, it is told that the defense sector should train non-technological personnel, including those at senior levels, to be familiar with AI, its limitations, its capabilities, so that its personnel can be more involved and active in making decisions in the field of AI. It is also told that Israel should develop norms and principles for ensuring safety and responsibility in the use of AI within security establishment, but with the intention that civilian bodies will adopt them as well. Also, it is told to create a code of ethics for use of AI in the security establishment. And for legal, moral, safety, redundancy purposes, Israel should decide which system should retain mechanism of human supervision and control. What is also interesting, the public sector should consider the management of personnel to recruit and retain talented people in order to not lose them to the civilian industry. And these are propositions for Israeli regulations. So to sum up my presentation, I would like to notice that AI is a technology that is revolutionary potential in all areas. It's being able to make a machine responsible for actions that were carried out by a person and to surpass them, even in areas where automatization was never imagined, has remarkable effects. So indeed, it is still difficult to fully assess the scope of the revolution and its characteristics, but it's impossible now to ignore the need to prepare for it and for its far-reaching implications. The regulations certainly need to be rational and maintain a balance. Over-regulation can destroy the potential of AI, while too much freedom can threaten to get out of control and simply endanger people. So it is important to take social and economic factors into account when creating law. So I hope that the presented examples of some good practices that are proposed in some national strategies can inspire in our research, which is also expected to result in the development of de lege ferenda postulates. Thank you very much for your attention, and if you have any questions, I'll be glad to answer it.
Thank you very, very much for your presentation. Are there any questions? I don't see none on the chat. So thank you for attending to our team's second scientific seminar. We warmly invite you to our next seminar, which will be held on 27th of September and will focus on access to the fair trial, trying to analyze the impact of artificial intelligence on fair trial. So thanking you for your attention. I wish all the speakers further fruitful research and all of you an enjoyable afternoon. So see you on 27th of September on the next seminar.